Welcome to Let's Talk Surrogacy. Today we're joined with Joanna Beck Wilkinson, a family building attorney from Foster & Bloom. Joanna, welcome.
Thank you. I'm excited to be here.
So nice to meet you. So I just want to get a little bit of your background and what brought you to family building law.
So I originally joined the practice that my mom built when I was very young, I think 9. She had started helping build families through adoption because of her background as a nurse practitioner. And over the years, the adoption practice sort of naturally morphed into family building because there became many more ways to build one's family. And now I would say that our practice is probably more collaborative reproduction than adoption. And when I say collaborative reproduction, I'm talking about sperm, egg, and embryo donation and or gestational surrogacy.
Thanks for that clarification, because I'm like, what does that mean? And I'm sure there's others.
So many different terms out there. Yeah.
Mm-hmm. Great. Well, at the most basic level, what is a surrogacy contract and what does that process look like?
So the legal point of a surrogacy contract is that everyone writes down their promises. And if one party, one side breaks their promise, then the other party, or what we call the aggrieved party, can get a court involved to what we call enforce the contract, get involved and make the other party do what they had promised to do. In reality, it is exceptionally very, very rare that courts get involved in surrogacy contracts. And so the purpose of them is really more logistical and emotional and intellectual because it helps the parties write down what they plan to do. And even though they've often talked about it in depth, sometimes in the best cases, they've talked about it in depth with outside parties, with mental health professionals, seeing it written down and talking to a lawyer about it really helps them get a deeper understanding of what they're signing up for.
Interesting. Yeah, it just kind of clarifies and gets it all on paper,
in
right?
Black and white. Yeah.
Okay. Mm-hmm. Are there parts of the contract that people often underestimate but end up being important later on?
That's a good question. I would say when a good matching program is involved, it is exceptionally rare that things go wrong. And I've been doing this I'm going on 18 years now. I have done this more times than I can count. And so I do really say that with confidence. It is very rare that things go wrong. When they do go wrong, they typically fall into one of 3 different categories. And the first one is management of pregnancy. So that involves everything from what the surrogate eats and the activities that she's going to engage in and her travel and whether or not this is something that randomly comes up from time to time if she has her own children who are in travel sports, how often she's leaving the state. That's a management of pregnancy issue. Management of pregnancy also includes her choice of doctors and her medical decisions. So it's her lifestyle and medical decisions. And again, things very rarely go wrong. When they do, management of pregnancy can come into play because the surrogate may have a different idea of how she wants to manage her pregnancy than the intended parents. Probably the best way to demonstrate that or to explain that would be by example. So very early in my career, I had a client who I will respectfully and affectionately refer to as a flower crown mama. Okay, this is the opposite of me. I was very high maintenance. All my kids came through the sunroof. But she was like, get me my crown. I will deliver in my living room. I mean, the best kind of mom, right? But on the other side, we had intended parents who were, they had just been through multiple heartbreaking failures and miscarriages and a stillbirth. And they wanted every high-level doctor and the most sterile OR. So it was a management of pregnancy issue, right? Nobody was right or wrong. It just wasn't the best match.
Yeah.
So like I said, things very rarely go wrong. When they do go wrong, they usually fall into one of 3 different categories. Management of pregnancy is the first one. The second one is termination of pregnancy. And this is the circumstances under which the parties have agreed to terminate a pregnancy, if at all. And the reason that there can be a misunderstanding with this is that people just have different ideas of how they're going to react when something happens. For example, if you have a surrogate who is, she has, let's just use an example. She has 3 small children at home. Okay. And she's very concerned about the health implications of pregnancy. And so if she's advised that there's a health risk associated with a heightened health risk associated with the pregnancy, then she may wish to terminate it.
Yeah.
Whereas the intended parents who have invested so much emotion and time, not to mention money, they may not want her to terminate a pregnancy. And then it can go in the other direction as well. If we see a quality of life issue, I've seen, unfortunately, in my practice, I've seen an incompatibility with life issue where the intended parents did not want to continue the pregnancy because the doctor advised that the fetus would not survive birth. And the surrogate did. She wanted to continue the pregnancy until it naturally resolved itself. And so the reality with termination of pregnancy issues is that you can't make someone do something. Right. A paper can't make anybody do anything, nor can it stop someone from doing something. So in both of those circumstances that I just described, the surrogate is going to do what she wants to do. Yeah. It's the intended parents have no control over that. So again, it's really rare that these things go wrong, especially today with medical science advancing, and being able to foresee both, whether the surrogate is going to be a good candidate for pregnancy and whether the fetus is likely to, or whether the pregnancy is likely to continue. But when things do go wrong, that's on the list. That would be
well, and I would imagine that's why these clinics and physicians on the front end, why that is such a crucial part of this whole process in making sure these things are really lined out.
As much as they can be. Yeah. So the third one is confidentiality, including and especially social media. And again, so much of surrogacy lawyers, our contracts, our practices are based on our experience. And so I've had some unusual experiences with social media and surrogacy. I had a case where the surrogate was a very, very well-known influencer. And even though she didn't do anything to disclose the intended parent's identity, she was famous enough that her followers followed her and were able to determine who her intended parents were. It reminded me, I'm going to date myself here. It actually reminded me of, I think it was the early 2000s when the actress named Sarah Jessica Parker she had a surrogate who was, I think, pregnant with her twins. And she was just so famous that people figured out who her surrogate was. And she had to ask them to please back off.
Yeah.
So when you get parties involved who are famous, it can raise confidentiality issues. Mm-hmm. And today, because of social media, anyone can be famous.
Right.
You don't have to be Sarah Jessica Parker anymore, right? Yeah. So I would say that's the third thing that people may underestimate walking in, that how social media will play into their arrangement if either side is particularly active on social media.
Interesting. I've never thought of that.
Yeah. Mm-hmm.
For surrogates, are there specific protections you always want to see clearly spelled out?
Yes, without question. And actually, the New York law, which was enacted, I want to say 2023, is probably the best statute that kind of outlines what those things are. The most important is that she needs to be the one who chooses her healthcare provider, chooses where she's going to deliver within certain guidelines, I would say. So it's reasonable to ask her to choose a board certified obstetrician or certified nurse midwife under the supervision of an obstetrician if the parties have agreed that's how they want to handle healthcare. But she needs to be the person who selects the specific doctor, because even though it is the intended parent's baby, it is her body and it is her pregnancy. So I would say her choice of the people who treat her would be one of the most important protections. Now, the intended parents often have already contracted with the IVF clinic, the fertility clinic, and so she's not going to get to choose that provider. But when it comes to her pregnancy, it's very important that she choose her own healthcare providers. And then the same is true at the hospital. I think it's reasonable if she's near a hospital that has a good NICU that the intended parents ask her to choose one that has a good NICU. But ultimately, that decision really needs to come down to hers.
Makes sense.
Yeah.
So for intended parents, are there terms in the surrogacy contract that often surprise them?
I would say probably the ones that come as the biggest surprise to intended parents would be the management of pregnancy provisions. They are often envisioning this as their baby, so it's essentially their pregnancy. And so the management of pregnancy provisions can often surprise them because they thought they would have more control over how management of pregnancy was handled, and maybe they don't.
Gotcha. The first draft of the contract is usually written by the intended parent's attorney. Why is that standard, and why shouldn't surrogates be alarmed by that?
That's a really good question. I have occasionally written contracts on behalf of surrogates, but generally speaking, I would say 95% of the time, it is the intended parent's attorney who writes the contract. And why should it? Well, in some cases, maybe surrogate should be alarmed by her contract. It all kind of comes down to the contract. I would say probably the more important thing is that she's really comfortable with her attorney, and that the two attorneys who are involved have a reasonable symbiotic relationship, collaborative relationship, and both of them want a process that works for both sides, because some contracts are very IP-centric, and others are more fair and balanced.
Now, this may seem like a silly question, but honestly, so I'm just kind of realizing that the surrogate does have to have her own attorney. Do the intended parents pay for that attorney? And so that's just kind of coming up for me.
They do. And actually, that's something that sometimes can surprise intended parents, because they often understand that they would be paying for her attorney. But then there's some confusion about why, if they're paying the attorney wouldn't be working for them.
Right. Kind of like this conflict of interest.
It is a very delicate role for the attorney representing the surrogate, because and I'm just going to go with her because I'm a woman, because her allegiance has to be to her client. It cannot be to the people who are paying her bill. And unfortunately, I've been involved in situations where there's been some expectation from the intended parents, and I've had to say, I'm sorry, you're not my client. Thanks for paying my bill,
right?
But I don't represent you. Yeah. In fact, it's central to my role. Like, it goes to the essence of being a lawyer that I am representing my client, not the person who's paying my bill.
Well, and then you could see how frustrating that could kind of be to the intended parents. Like, well, now look, why are we changing this contract that's more favorable?
We're paying you to fight with us.
Yeah.
Yes. Yeah, exactly. Yeah.
Well, thank you for clarifying that, because, I didn't know that. Can you explain what happens during the review and negotiation stage of the contract process?
So usually, as we discussed, the intended parent's attorney writes the contract on their behalf. And then in my case, I send it to them, ask them to review it on their own. And then we schedule a Zoom meeting and we go through it together and cover their questions, any changes that they want to make. And then I will send the intended parents a revised version of the contract for them to review, with my changes or the things that we've discussed outlined in the margins, so they don't have to hunt for what we've discussed. Sometimes there will be another meeting because they have more questions. Sometimes they'll say, this is great, and I will clean it up so that what we've discussed is not still visible. And then we send it to the surrogate's attorney, who will do essentially the same thing. She'll send it to the surrogate for review prior to a meeting. Then generally they'll meet via Zoom. And meeting via Zoom is helpful because it's nice to be face-to-face, but also because then they can screen share and be looking at the contract at the same time.
Oh, nice.
And so that's kind of how the review proceeds. And then they do the same thing. They go through any questions the surrogate has. If there are any changes, usually there are, then they'll make them together, and then the attorney will send it to her client. Surrogate reviews it herself, and then they send it back to the intended parents. And sometimes that will go back and forth a few times, particularly if the attorneys are not used to working together, or if either side just has really strong feelings about the contract. But then generally speaking, the parties come to an agreement. They accept all of the changes, clean it up, and create what's called an execution copy. And then now, because of my professional organization's rules and several state statutes, generally it would be notarized. All the parties would sign in the presence of a notary.
So just curious, has it ever gotten to, have you seen where a contract is the sticking point and they can't get past that, and therefore they don't work together?
I've seen matches fail, yes, because of contracts. I would say it's pretty rare, particularly when there's a good matching program involved and when the parties have met with a joint counselor and they've flushed out some of the hot button issues ahead of time. It's pretty rare that happens, but it does, and it should. It should.
Right,
matches
better
should not
on this
proceed.
side.
Yes, exactly.
Later on.
Than later.
Yeah.
Yes.
What does legal clearance mean, and why is it such a major milestone for both surrogates and intended parents?
So earlier when I was saying there's a legal purpose of a contract, and then there's also the practical and emotional and intellectual purpose of the contract, then we have this logistical purpose of a contract. And that is that a clinic will not proceed with embryo transfer until they have the go-ahead from the lawyers. And that is what we call legal clearance.
Okay.
And so sometimes I'll have intended parents call and be like, we need a legal clearance letter. And I'm like, actually, you need a surrogacy contract.
Right.
After which point I will write you a legal clearance letter. And that's when your clinic is going to be ready to proceed.
When it comes to defining parental rights in surrogacy contracts, why does legal clarity matter so much for surrogates?
So that's a good question. So unfortunately, there can be misunderstandings on both sides. And sometimes a surrogate may envision her role after birth to be different. She may envision herself more as being involved in the child's life after birth, walking in. And then on the other side, it's important for intended parents to understand that the surrogate, once she's done giving birth, is not going to be involved anymore. Unfortunately, I have had situations where intended parents expected the surrogate to take the baby home, nanny the baby for some period of time, particularly.
Whoa.
Yes. Yeah. So it is important to spell that out in the contract and say, so that we all understand, after birth, the surrogate is going to go home and have a glass of wine, maybe some sushi. I don't know, go on a roller coaster. What are we not allowed to do when we're pregnant, right? Put our feet up, sleep through the night.
Right.
Yeah. And then the intended parents are going to take the screaming baby home, right? And they're not going to sleep.
Yeah.
And they are going to be the legal parent. So that can be important for both sides to understand.
I would imagine so.
Yeah.
So the first draft can feel intense or one-sided, as we've kind of discussed. Why is that actually normal?
Well, technically speaking, the attorney who's representing the intended parents her job is to advocate for the intended parents. And so the contract is going to be a reflection of the intended parents' interests. And so it can seem one-sided when it comes to the surrogate. Now, those of us who've been doing this for a long time and who are used to working together are not going to encourage our intended parent clients to put something out that is just from the beginning inherently unfair to a surrogate.
Yeah.
We're going to try to manage expectations from the beginning and explain to our clients that this is not the sale of land or a money deal. This is a collaborative relationship and both sides need to benefit from it.
Yeah.
And so putting forth a contract that's not going to provide basic protections from their surrogate from the beginning it's just not a good place to start.
Kind of red flag.
It is.
Yeah.
It really is, yeah.
Yeah. So some surrogates worry that asking for changes will rock the boat. From your experience, what does advocating for yourself during the contract phase actually mean?
I would say the single most important thing is reading the contract carefully and asking lots of questions. When it comes to changes, I'm not sure I've ever had a contract where I was representing the surrogate and I did not make changes to send back to the intended parent. I would say it's expected. Yeah. Almost. As long as the changes are reasonable and the surrogate's attorney is going to be honest about what's reasonable, I don't think surrogates should feel shy about that at all.
It kind of reminds me of like a prenup. Like you're going back and forth and it's like, well, I think that this would be a little more fair. It's just a negotiation to where you both feel good about the final outcome.
Yes. And the idea is that you're continuing as friends afterwards, right? And so everybody wants to. It's a collaborative process. It's non-adversarial.
Yeah.
But you still need to advocate for yourself. Right. And your lawyer really needs to advocate for you too.
Yeah.
Yeah.
How long does the contract phase take and what could help speed it up or slow it down?
That's a good question. Because often they will be awaiting medical clearance from the clinic, so that they're waiting for the surrogate to get medical clearance from the clinic. And sometimes the clinics will say, okay, you have medical clearance, you can start meds in 2 weeks. And then everyone's like in a huge rush to get the contract phase done because they can't do that transfer until they have legal clearance.
Right.
So, so what would be a good way to avoid delays? I think joint counseling would be the single most important thing that's going to keep a contract moving forward, because they will have talked about the hot button issues ahead of time: management of pregnancy, termination of pregnancy, social media, and other things that the parties may have thought about conceptually but not talked about together with a professional ahead of time. And if they do that with a joint counselor, and if they work with attorneys who have worked together before, that can be really helpful, then generally the contract is going to proceed smoothly, and I won't say quickly, but certainly more efficiently than if those things have not occurred.
What costs are intended parents typically responsible for during the legal phase?
So the intended parents are responsible for paying for the surrogate's attorney, both for contract review and for the establishment of parentage. They're also responsible for ensuring that she has adequate estate planning or incapacitation documents, because if she becomes incapacitated or while she's pregnant, or if she dies and the child survives, then they need to make sure that her estate planning documents reflect her intentions with regard to the child. So I always say that estate planning law, if estate planning law is neurosurgery, then surrogacy is radiology. They are totally different. They have totally different rules. We don't talk to each other much, and there can be a lot of points where they don't work together well. So for example, in a surrogacy contract, it will say up and down: the intended parents are going to be the parent, the surrogate is not going to be the parent, the intended parents are going to be the legal parents, the surrogate is relinquishing all rights, et cetera, et cetera. If the surrogate were to die and the child were to survive, her estate, and if she were to die without a will, then her estate would go to what's called probate court. Mm-hmm. And this is our neurosurgery. Okay, they don't know anything about surrogacy, nor do they care. They have their own rules. They're very specific. And the only thing that they're going to take as evidence of her intent is going to be a validly executed testamentary document. They're not going to take a surrogacy contract. And so it's really important that she have a living will reflecting that she intends only for her children to inherit from her. She does not intend the child to inherit from her, and that she intends for the intended parents to be the child's guardians.
A lot of fun things to have to think about as you're getting ready to jump into.
Unfortunately, yes, it has to be. And I should emphasize the importance of a valid testamentary document, because I sometimes will see attorneys who will draft up something quick that will go with the contract for a surrogate to sign. And I look at it and I'm like, I'm a radiologist. This doesn't look like something that a neurosurgeon is going to take.
Right.
I think she needs to go see a probate attorney and get a validly executed testamentary document.
Yeah, that makes sense. So why is it important for intended parents to work with attorneys who specialize in surrogacy law rather than general practice attorneys? Kind of touching a little bit on what we already discussed, but maybe there's more to that.
Yeah. I mean, I think just to go back to the medicine example, surrogacy it's unlike any other area of the law. Those of us who do it have been doing it for a long time. There are things that other attorneys just wouldn't occur to other attorneys that happen in surrogacy. I would say probably one of the most important things is the collaborative nature of how these matches move forward, because other attorneys are used to fiercely advocating for their client, opposing another client. But in surrogacy, it's a collaborative process.
Yeah, that is. I hadn't even really thought of that. It's like the common goal is really shared by both parties.
It is. The attorneys need to get along. Everybody needs to have the same goal. The idea is to get to yes. It's not to win.
Right.
Yeah.
That is.
If somebody's winning, then there's a problem.
Yeah. Well, that's actually kind of interesting for you as an attorney. It's a totally different take on the law.
It is, yes.
Yeah. Are surrogacy contracts legally enforceable?
Really good question. So they are in states that have a statute. So there are two different kinds of law. There's statutory law, which is where the legislators sit down, they pass a rule, and it's written probably in a book somewhere. And then there's case law. And case law is developed when there's a problem between parties and it goes up to a high court, and the court assesses the situation and writes an opinion, which creates what we call case law. So some states have statutory law, some states have case law that talk about whether or not a contract is enforceable. Some states have neither. Missouri would be an example of a case that has neither on surrogacy contracts. Kansas would be another one.
Interesting.
And so in those states, when I talk to my clients, I say, I can't promise you that this contract is enforceable. And it's not just about the enforceability of the entire contract. It's also about certain things that are in the contract. I usually tell people that when it comes to the single most central important part of the contract, and that being parentage, it's likely enforceable. It's likely that the court's going to hold that the intended parents are the parents and that the surrogate is not the parent, assuming that they have followed all of the ASRM guidelines and that they've taken all the precautions necessary and that the surrogate's not genetically related to the child. And that's not just based on my prediction. That's based on having read case law from other states that did not have statutory law or case law. So Iowa, Wisconsin, Pennsylvania, Ohio, none of those states at the time had statutory or case law. And they all had cases that went up to a high court, and the court found that the surrogacy contracts were enforceable, at least with regard to parentage. All of the other promises, I can't tell you that they would be enforceable. But generally speaking, when it comes to parentage, as long as they've taken all the precautions, most surrogacy lawyers, I think, are pretty confident that the contracts are enforceable.
What constitutes a surrogacy contract amendment, and how can that amendment be enforceable?
They're not. It's kind of a fraud. And one of the first things we learn in contract law is that a contract is an exchange of promises or performance. And when you make a change to one of those promises, it does not become an enforceable change unless there's another promise from the other side. So the short answer actually is no.
Yeah.
It's a good idea to write it down anyway.
Yeah.
But contract amendments are generally considered, at least by the experts, not to be enforceable.
So does the state governing the contract need to have statutes on surrogacy contracts?
That's preferable, assuming that it's a good law. And some states do not have great law, but not necessarily. As I was mentioning earlier, so Missouri and Kansas, we don't have statutory or case law on the enforceability of surrogacy contracts. But when it comes to the most important part of the surrogacy contract, that being legal parentage, I believe that it's likely that a court would enforce it, assuming that the parties have taken all the necessary precautions. And that is based on what's happened in other states. So Iowa, Ohio, Pennsylvania, Wisconsin were all states where there was no statutory law or case law. And there were cases that went wrong. They went up to high courts, and the courts did enforce parentage. They did say intended parents are the parents, gestational carrier is not the parent.
Yeah. What role does jurisdiction play in how a contract is written and enforced?
Okay, so I would call that a choice of law question. And choice of law is really important in surrogacy contracts because the law that the parties choose to govern their contract is going to be better in some states than others. And so it's a good idea for the parties to talk to their attorneys about what possible choices of law are available to them, because they might wish to choose a law that is more specific when it comes to surrogacy contracts, more likely to be enforceable, and more likely to protect them.
What happens if a surrogacy contract is drafted in states where the laws aren't clearly defined?
So if we have a contract that was written pursuant to the laws of a state that does not have statutory or case law, nothing, unless something goes wrong. And unless somebody breaks a promise or somebody believes that someone has broken a promise, and there's what we would call a breach of contract. Mm-hmm. The first thing that would happen, ideally, is that they would proceed to mediation and talk through the situation with a mediator and their attorneys and possibly a counselor to try to resolve the issue. If mediation or counseling did not resolve the issue, and if the parties felt that a court needed to be involved, then one party would sue the other party for breach of contract. Depending on what promise was broken, it's more or less likely that a court would get involved. If the promise that was broken was the intended parents are trying to get out of parenting, okay, which I've read a lot of cases, and that's, believe it or not, it's not that uncommon.
Wow.
I'm pretty confident that a court is going to get involved and tell them, you signed up for this.
Yeah,
you're going to need to be parents. If the gestational carrier tries to keep the baby, which is so unbelievably, exceedingly unlikely and rare, again, the court's going to get involved and say, you signed up for this. You gave informed consent. You had an attorney. You did your mental health evaluation. You were protected in every way. You knew what you're signing up for, and you're not the parent.
Right.
So I don't think it would necessarily matter if it were Iowa that has no law versus New York that does have a law, as long as we're talking about an important promise. If the promise is she promises not to sleep next to her cell phone, okay? I don't think the court's going to get involved.
That. No. Yeah. So what are contract provisions, and what provisions should surrogates watch out for?
I would say the most important provisions that a surrogate should watch out for would be her healthcare decisions, that she's able to choose her doctor. Again, I think it's reasonable that she choose a board-certified obstetrician or a certified nurse midwife under supervision of a board-certified obstetrician, and that she promised to follow doctor's instructions. That's a reasonable expectation. But having her choice of doctor subject to veto, for example, or a second opinion or substitution of her doctor, that would be a big red flag for me. Another big red flag for me are these really punitive provisions that have her, for example, paying back all the money that the intended parents have spent if she sleeps next to her cell phone.
Gotcha.
That's overly punitive. A court's not going to enforce that anyway. It's not productive for the parties.
Yeah, I would think that would make that whole process a little icky. Like, really?
Yeah, adversarial.
Yeah. Now, from a legal standpoint, what are the main differences between agency-supported and independent surrogacy contracts?
Well, it would depend on the state. If the parties, for example, are in New York and using a New York contract, then there are very specific programs that they can work with. And the programs have to follow certain rules, and there are certain protections that are available for both sides. In other states, legally, there's not a difference because other states don't license programs or agencies. That's definitely an evolving area, and I would like to see more states do that. But right now, New York is the only one that does.
What risks do you see more often when people try to navigate contracts without an agency?
Well, so that's a good question. It is nuanced because it depends on how good I use the word program instead of agencies because I started my career in adoption. And in adoption, there's a very important distinction between an agency and a non-agency because an agency is a licensed child placing agency. So I say program, even though there actually is one program in the country that is also a licensed child placing adoption agency. Most of them are not. So let's say we have a good program involved. The risks that I'm going to see in an independent surrogacy versus a surrogacy where there's a good program involved are going to be the parties' expectations. They're both walking in with what they think are the same expectations for their shared pregnancy. And usually they are not. And they haven't talked to a joint counselor, and they haven't considered all sorts of risks. One of the more common problems that I see is that when the parties come to me, they have not talked about the important psychosocial stuff involved in these matches, and I'm just the lawyer. And so a good program is going to have the entire psychosocial sphere covered.
Yeah.
For the parties.
I'd imagine that would be important.
A good program is also going to vet both sides.
Right.
That is so incredibly important, and it's been a growing issue in our field.
How does having a coordinated legal and agency team improve outcomes for both surrogates and intended parents?
I would say that's really important for efficiency, for expectations, for general copacetic, productive relationship when the program and the lawyers are on the same page about things. Because if they're not, then the contract can look very different than what the program has presented to the parties ahead of time with regard to not just money, but also with regard to logistics, with regard to choice of doctor, with regard to clinical schedules and things like that. When the attorneys and the program work together and when they're used to working together, things are going to move more efficiently and everybody's going to be happier.
Is it common for clients to feel anxious or overwhelmed when they see how long and technical surrogacy contracts can be?
Yes. And there's very much a movement. It's called the plain language movement in the legal sphere to make contracts. Reducing the volume and the length is harder, but putting them in terms that everyone can understand is really important. I'm a big fan of the plain language movement because honestly, it's gotten to the point where like the lawyers don't even know what we're saying anymore. There are so many here fors and here twos and therefores, and as referenced by, I would say that contracts that are in plain language, they use the parties' names. That's a big one. Don't call me gestational carrier. Call me Joanna.
Right.
So that I can figure out what Joanna is supposed to do. It is very common that the parties are pretty overwhelmed when they see the surrogacy contracts, but there's definitely a contingency of us who are trying to move towards the plain language movement. I would say Attorney Robin Pope in Oregon, I really like her. She's really pushing it. She's doing a great job.
Well, when you had said early in our conversation about it's really important to read the contract, I'm sitting there thinking, yeah, but those are really hard to understand for someone who's not an attorney. I'm relieved to hear you say oftentimes attorneys are like, what does this even mean?
Yes.
Like, where'd this come from?
Exactly. So, yeah. If you are struggling to fall asleep at night, you should pull out your surrogacy contract because it'll help you.
Just let it play like an
That's
audiobook.
right. Yes.
Yeah. Oh, my goodness. How do you help first-time clients move past the fear that they're missing something or they don't understand enough?
Unfortunately, the lawyer's job is not as much about making people feel better,
right?
And more about
It's like a surgeon.
Yeah, I mean, we're warning them about the risks.
Yeah.
It's I always start my conversations by saying I'm not actually a definitively pessimistic person in life. I am not Debbie Downer, I swear. And things very rarely go wrong. But it is my job to warn them about the worst case scenarios and make sure they understand what's at stake.
Well, it's kind of better to be prepared and know what is, that way you can make an informed decision with all the facts and all the things that could potentially go wrong.
Yeah, and I do believe that an attorney's role is not to be a yes man.
Yeah.
If your attorney is all sunshine and picnics, that's not what we learned to do. That's not, there are other people who do that. Your lawyer really needs to be quite serious about the risks involved.
Yes. Yeah. So why is it so important for each party to have independent legal counsel review the contract?
That is so important because the parties often think that they have the same interests walking in. And even if they are family, because there are a lot of familial arrangements, they don't have the same interests walking in. They have naturally conflicting interests. Even though they want the same thing, their interests are often diverge. Usually not in a really important way that would break the match, but certainly they need their own attorneys to protect their interests. Pregnancy is a really big deal. It's really dangerous.
Yeah.
Women are much more likely to have really serious health problems while they're pregnant. In my 18 years, I have had multiple surrogates who were very, very ill or made very ill by pregnancy. It is so important. They need to have their own lawyers so that they can understand those risks.
Yeah.
Yeah.
If you could give listeners one piece of advice before they sign anything, what would it be and why?
Read it. Read it. I have so many clients, I think, who just skim it. And I know it is tempting to skim it. But taking that extra time to try to get through it and ask the questions and make sure you understand what you're signing, that is the best time that you will spend.
Well, now with ChatGPT, you can literally put it in there and say,
what does this mean?
Yeah,
Yes.
put it into layman's terms for me,
Yeah. And then ask your lawyer and make sure that ChatGPT was right.
Yeah. If a first-time surrogate is listening right now, staring at a long contract and feeling overwhelmed, what perspective would you want them to have?
Get through it. make some notes in the margins. It always helps to have a pencil, okay? If you have it printed out, or if you're reading it on a screen, have it on a tablet so you can make notes. Get to the end and then talk to your lawyer. And make sure that your lawyer and you are looking at the contract at the same time together. Your lawyer is going to be like a translator.
Yeah.
And your lawyer is going to choose a good lawyer that you trust, and your lawyer is going to take care of you.
If you could change one misconception people have about surrogacy contracts, what would it be?
Okay, so if I could change one misconception about surrogacy contracts, it would probably be that they are a technicality and just sort of a hurdle that just needs to be cleared. They're much more important than that. They really do spell things out for the parties, and they really help the parties understand what they're promising to do. So I guess it would probably be that they're just an unimportant technicality. They're really important. Take it seriously.
A fundamental piece to this whole
exactly.
process.
Yeah.
Where can people go to find trustworthy legal guidance as they prepare for the contract phase of their journey?
So ChatGPT is a great resource. I use it myself. However, I've asked it some questions and gotten some pretty alarming answers about surrogacy. So that probably wouldn't be the place that I would start. The American Society for Reproductive Medicine has a division called the Society for Assisted Reproductive Technology, and they have guidelines that they publish for surrogacy. I would look those up. I want to say they were most recently published in 2018, and then there was an addendum or an important change, I think, in 2023. So I would definitely look those up and review them. American Surrogacy has a really good site. It's really informative. There's a lot of helpful information on it that's not overly definitive. It's more about like asking the right questions. And so I do really like American Surrogacy's site. The Creative Family Connections map has been around for 25 years. And they consult attorneys in every state before making it. From what I've seen, they're good attorneys, and the information is really good there. So I would say those three are really good places to start.
Well, I want to thank you so much for taking the time to sit down with me and discuss all of these legal jargon, technicality, all the things that come up when a surrogate and an intended parents come together to write these contracts. The information is super valuable, and I just really appreciate your time.
Thank you so much for having me. I really appreciate it.